For most people, if you don't have a will or a trust, the state decides who gets your assets, and it might not be who you'd actually choose. In this video, I'll show you who gets what when someone passes away without a plan, and we'll go over how to retake control of things ahead of time so the state isn't deciding everything. My name is Jack Duffley, and I'm the founding attorney of Duffley Law. We're a Texas-based law firm, and we help families avoid probate and make sure their wishes are followed, not the state's. And before we can go further, we have to understand the difference between what we call testate succession and intestate succession. Testate succession is when someone passes away with a will or generally with an estate plan, so they've made their wishes clear and what they want to see happen. On the other hand, we have intestate succession. This is when someone passes away without a will or valid estate plan. So when someone passes away intestate, that is without a will, we look to whatever the state says should happen to that person's assets. Every state's going to treat this a little bit differently, but let's take a look at Texas for an example. We actually head on over to the Estates Code, which has all sorts of information about what happens after someone passes away, depending on the type of plan they have put together, if they have a will or a trust or any other tools. It's pretty much all laid out in here. And the key section we're looking at here is the intestate succession section. And this says everything that you would need to know about who gets what when someone passes away. And that's when they pass away without a will, when they are intestate. And there's a lot of different scenarios here because it depends on that person's family history, when different people passed away in the family tree. Were they married at the time? Were they not married at the time? Were they married and had kids outside of the marriage? Let's go through an example. A lot of people just assume that, oh, if I'm married to someone, my spouse is just automatically going to get everything. And in some cases that might happen, but in others it very much might not. So as an example, in this first section, it goes over who gets what when someone passes away not leaving a spouse. So as an example, if someone dies without a spouse and they don't have a will or other plan, then generally speaking, it goes to the person's children and the children's descendants, if any children predecease that person that we're talking about here. But if there's no children, then it generally goes to that person's parents. But if only one parent's alive, then it's going to be split again. If there's no parents alive, then we're looking at siblings and siblings' descendants and so on. It just keeps going down the list. And this very much might not be what you want to see happen. But it doesn't matter because if you don't have a plan, the state is going to look to their plan that they basically have for you. Let's look at someone who's married in Texas if they pass away intestate. And in Texas, what happens is if someone passes away and they're married, we have to look at a bunch of different family details to see who gets what. And we also have to distinguish between what we call separate property and marital or community property. Community property is basically jointly owned property by spouses. Different states have different rules about that kind of arrangement. But anyways, you can see here that there's a bunch of different things that we look at when a married person passes away. Do they have children? Because let's say we have someone who passes away. Section 2012 says if the person has one or more children, then the surviving spouse takes 1/3 of the separate property of the estate, of the separate personal property, I should say. And then 2/3 goes to the kids. So even if you wanted everything to go to the spouse, then that might not be what's happening here, for at least with separate property. And then the surviving spouse is entitled to a life estate in 1/3 of the person's land. So this is real estate. They get a life estate so they can technically use the property for their life, but then that expires after they pass away. But anyways, that's just separate property. We scroll on down further, we can talk about community property. If a person leaves, jointly owned community property, then that person's half may not actually end up going to the spouse like someone might be expecting. Instead, what we actually see happen in a lot of cases, especially with blended families, we look at this restriction right here. The community estate of the deceased spouse passes to the surviving spouse if no child or other descendant of the deceased spouse survives the deceased spouse, or all of the surviving children and descendants of the deceased spouse are also children or descendants of the surviving spouse. So that means is if we have a blended family where children are coming from both sides of the family and not all of the children are from the same parents, basically, we have a situation where the children are going to be inheriting a large portion of the estate, potentially half of everything here if everything's community property. And that's what 2013C says. If the deceased spouse is survived by a child or other descendant who is not also a child or other descendant of the surviving spouse, the deceased spouse's undivided 1/2 interest in the community estate passes to the deceased spouse's children or other descendants. Now, there are all sorts of exceptions and other rules, but I think you get the gist. The point is, this might be very different than what someone is actually expecting when someone passes away, even if they don't have a will, we might be thinking, spouses get everything automatically, right? Well, in some cases they might, and in many others they don't, and that can be a big shock for people. And that's before we talk about situations where there might be multiple deaths in the family, or there's a bunch of different heirs or other descendants that we're not really aware of, but we know they might be out there and they might be inheriting something, and then we got to figure that out. And it can really turn into a big mess. And we deal with that all the time at our firm, where we have people who have what seems like a simple situation on the surface, but then we come to learn that this person might have had other children, and maybe those children predeceased that person, so then their children's children end up getting things, and it just, again, it can really quickly devolve into quite the mess if things are not organized properly. But what can we do about it? Thankfully, we can do something about it with effective estate planning. And it doesn't have to be anything super grand or complicated. Just having a clear, well-articulated plan can avoid so much hassle down the line. And of course, it can outline exactly what you want to see happen rather than letting the state decide based on whatever their rigid statutory code might say. A last will is the most common tool that people put together to make sure their wishes are clear and where they want to see things go and who they want them to go to and who's managing those things. All of that can be predetermined by writing out a clear will and making sure that will is executed validly according to the terms of the state, and making sure that it can hold up in probate court if it's ever needed. A more powerful tool in a lot of situations is something like a trust. You can think of the trust like a bucket. We create this bucket here today. We move as many things as we can into that bucket, and then anything that's in that bucket when someone passes away avoids the probate process entirely, so there's no need to go to court, and it makes clear where that bucket is supposed to go. So we'll have instructions for as to how things are supposed to be handled out of that bucket and who and where everything's supposed to go to, rather than looking at whatever the state would say if there was no plan at all. The keys to success here are, for one, taking the time to think about who you want things to go to, and then second, actually putting that down in an effective and valid estate plan, so we're not even having to look at what the state would have you do if you didn't have a plan. The bottom line is we don't need to leave things for the state to decide. With the right plan in place, you stay in control of who gets what and when. If you have any questions, feel free to reach out to our team and we'll do our best to help. I'll see you in the next one.